Honorable Supreme Court of India passed a judgment on child pornography. Now, this judgment is being hailed as a landmark judgment as it reiterates a protection of human rights, but in particular, children's rights.
Correct. So, yes, Sandhya, adding to that, these are very important views which we need to share with our viewers, in fact. So, if you look into in 2020, one Mr. Harish of Chennai was booked under the Protection of Children from Sexual Offences, which we know it is called as a POCSO Act, for possession of the child, pornographic content on his phone, right? So in September 2023, a charge sheet was filed against him under the provisions of the POCSO and also the Information Technology Act.
Right.
So when Harish approached the court, that is the Madras court, the court acquitted Mr. Harish in January 2024, stating that mere possession or storage of child pornography was not an offense under POCSO. It further ruled out that a person would be held guilty under the Section 67B of the Information Technology Act only if an act of transmission, publication or creation of the child pornography is done and not its watching or downloading.
A bunch of NGOs involved in protection of child rights, going by the name Just Rights for Children Alliance, appealed against the Madras High Court decision in the Supreme Court of India. Now, it was their contention or submission that by decriminalizing the act of mere possession or storage or downloading child exploitative content would send out a wrong signal to the society, as in it would indirectly say it is okay to do stuff like that. It would actually end up increasing a demand for such content.
Very true, yes. So, while hearing the appeal in March 2024, the Chief Justice of India remarked that the Madras High Court judgment was within courts atrocious, right? Finally, on 23rd September 2024, a division bench of the Supreme Court passed a judgment overturning the Madras High Court ruling. So, in doing so, what happened is the apex court held that even mere viewing, possession and storage of any material depicting minors who are engaged in any kind of sexual activity will constitute as an offense under the POCSO Act.
Subathra, I reiterate what you just said. Consequent to the 23rd September 2024 judgment, now mere storage of child exploitative or pornographic content will now be considered an offense under POCSO, right?
Right. So here also, Sandhya, the court has pointed out very clearly that Section 15 of the POCSO contains different provisions capturing the intention. Like, for in fact, failure to destroy or report child content is considered as an offense.
Right. In fact, I'd like to add here, the judgment also in so many words states that not deleting or not reporting such content indicates an intention to sexually exploit children, right? It doesn't matter if such content is stored without the intention to further transmit, but just not deleting or reporting will be considered as there is an intention to exploit children.
Absolutely. So adding to that, Section 67B of the Information Technology Act, if you look into, it straight away penalizes any such content, which is including even the intermediaries such as websites that contain such kind of pornographic content of children.
Right. In the course of delivering its 200-page judgment, the Honorable Apex Court also made some very meaningful suggestions and recommendations. To look at a few of them, and the most important one, the court recommended that the word child pornography not be used. And this is because pornography is usually associated with adults and adults who are consenting to participate in an adult activity like pornography. So therefore, this would be a misnomer for children who do not know, and so therefore the question of consent doesn't arise, who do not know the abuse to their physicality, much less they don't know the lasting impact that it will have on their physical and emotional well-being. So the court stated that the term child sexual exploitation and abuse material, or CSEAM or CSEAM as it may be called, is more appropriate as it kind of truly reflects the reality of the exploitation and its impact on children.
I think that's a very fantastic term which the court has put forth.
Yeah.
And again, it has reiterated the importance of sex education for children and especially for youngsters. It has stated that it must not restrict it just only to biological aspects of mere reproduction, you know. So it must also include like consent, healthy relationships, gender equality, and respect for diversity, right? So the stigma around such discussions also must be overcome in such a way that children or kids don't turn to the internet to get answers for their curiosity, right? So I think a lot rests in the hands of parents today, as well as in school, where they can openly talk about this topic, right?
Absolutely.
So I think this is a truly remarkable judgment for our country.
I totally agree, Subathra. See, child sexual exploitation is one of the most unimaginable and heinous crimes possible on children. Any step towards protecting children, their rights to their body or their emotional psyche is most welcome, is a step towards a progressive nation and a society. This discussion was just our attempt to bring this across to all our viewers purely from the objective of spreading some awareness on the same. We hope our viewers found it good. Thanks for watching.
Thank you. Bye.